How do you win a Q claim? That is what a lot of people call us wanting to know. And so today's video, we're going to discuss it. All things Q.
My name is Greg. I'm a VA disability attorney. Victoria is my wife and also a VA disability attorney. And we've been practicing VA disability law for over a decade.
All right. I want to just jump in with a series of questions. A lot of people call us asking about Q and don't actually understand what it is. So first, what does Q stand for?
Q stands for clear and unmistakable error.
And what is the legal standard for a Q claim?
All right, the legal standard for a Q claim is on the screen. I have this definition from a case from the U.S. Court of Appeals, Boaton versus Peek. And the court said that in order to establish clear and unmistakable error, you have to show three things. One, the facts known at the time of the decision being attacked on the basis for Q were not before the decision maker, or the law then in effect was incorrectly applied. The second requirement is that an error occurred based on the record and the law that existed at the time. And three, the most difficult part is, had the error not been made, the outcome would have been manifestly different.
Okay, can you explain that in more plain terms?
Yeah, so requirement one basically means that either the decision maker at VA missed some fact. For example, like the VA examiner gave a favorable nexus opinion and the VA decision maker misread it and thought it was an unfavorable opinion, or VA did not correctly apply the law back then. A common example of that would be they forgot to apply 38 CFR 4.59, which directs VA to give a compensable rating for any service-connected joint where there's painful motion. The second one is that the error just happened based on that first requirement. And then the third one is, had the error not been made, the outcome has to have been manifestly different.
Do you have an example of something that would apply?
Yeah, so what this means is that the outcome would have to be undebatably different. Like VA would have had to have made, essentially the opposite decision from what they made in the decision that you're attacking.
Do you have an actual case that you can think of? I feel like it's easier sometimes to understand in terms of real situations.
We win a lot of Q claims on that section 4.59 for painful motion. And you'll see this veteran makes a claim for their back condition. VA comes back, they grant service connection, and they assign a 0% rating because the veteran had full range of motion. And the decision maker, or VA, missed in the examination for the back that the veteran reported painful motion of his back. And so that would be a misapplication of the law and facts. And had VA properly applied section 4.59, it's undebatable that they would have awarded a 10% rating instead of 0% for that back condition because the veteran had painful motion in their back. Another example could be, like I was alluding to before, the VA employees sometimes misread things. So a veteran makes a claim for his back. The examiner says, yes, this is at least as likely as not due to this injury in service. And then the rating decision comes out, and the rating decision says, the examiner said it is less likely than not that your back condition is related to service.
Right.
Clearly, the VA employee misread the nexus opinion. Mm-hmm. And so you can go back and attack that decision and say, this is clear and unmistakable error. The examiner actually said, it was at least as likely as not related to service. And then you can get that decision changed.
Okay. And if you are to file a Q claim, what's the general timeline that you're looking at?
Yeah, so this is an area of confusion. You only use a Q claim when you're trying to change a decision that is no longer appealable. Okay. So if you're within a year of a decision, you would just do a normal appeal. And so in that last example, if the examiner actually said, it is related to service and the decision denies you because they said the examiner said it was not related to service, you would just file a regular appeal. In that case, you'd probably do a higher level review because you don't need to submit new evidence. You can just point to the VA exam and say, look, this was actually a favorable nexus opinion.
Right.
And so that's a big misconception. Oftentimes vets will be like, I want to file a Q claim against this decision that came out last month. No, you just file a normal appeal. Q claim is only when you're trying to change decisions that are outside the appeal period. So greater than 1 year from the decision. So you're trying to attack, a rating decision from 1970 or 1980 or 5 years ago or 3 years ago. That's when you use a Q claim. And there's no time limit. You can file a Q claim at any time.
Okay. Yeah, I was going to ask that. With something like a supplemental claim or a higher level review, are there time limits on when you can file those?
Yeah, you have 1 year to file generally any type of appeal, a higher level review, a board notice of disagreement, or a supplemental claim.
And then a Q claim, it's indefinite.
Yeah, and the standard to win a Q claim is high because there has to be some finality to decisions. If people could just keep appealing over and over, outside the appeal period, VA would be swamped. And this is a concept that applies to all law. There has to be finality. And so a Q claim is a last-ditch Hail Mary effort to try and change something that's already final. And that's why the standard to win them is so high.
And so once you do file it, how long until you're looking at a decision?
Yeah, so most Q claims you'll file at your local regional office. There is an exception to that. If you had an old decision and you had appealed that decision timely to the board and the board issued a decision, you actually have to file a Q claim against that board decision, and that has to get filed with the board. So you do want to be careful about that. But assuming it's a normal Q claim, you're trying to change a local regional office decision, you would file it, and generally it's treated as like a new claim. So, on current timelines, you're looking at probably 3 to 6 months to get a decision on it.
Okay. Assuming it's granted, how far back do the retroactive benefits go?
It goes back to the date of the decision that you're attacking. We've successfully won Q claims against decisions that are 50 years old. So, they go back and change the decision that you're attacking. So if you're filing a Q claim against a 2010 decision and you win, VA is going to back pay you back to 2010.
Is there any overlap between Q claims and presumptive conditions that weren't presumptive back when, but are now? Is there any room for veterans to get paid?
No, because an important thing to remember about Q claims is that the record, the evidence is locked to what it was at the time of that decision. So if you're filing a Q claim against a 2010 decision, VA cannot look at any evidence past 2010. It's only going to be from what was in the record at the time of that 2010 decision. And likewise, it's based on the law, how it was back then. So new laws, new evidence do not matter for Q claims. It has to be based on how it was back then.
Because Q claims only look at the record as it existed at the time of the original decision, how do veterans handle cases where there was missing evidence or things were misfiled?
Yeah, I mean, it's probably not going to be a winnable Q claim. There's no way around that. The record is locked. That's it. Which brings up another point, and it's kind of the same question, but like VA's failure of the duty to assist is never Q. So you can't say, the examination you got me back in 2010 was inadequate. They didn't write down all the symptoms. Yes, that may have been error, but it doesn't rise to the Q level because we don't know what the outcome of the case would have been if the examiner, wrote down all the symptoms you told them. VA may still have denied it. And again, that to win a Q claim, it has to be undebatable that the outcome would be different. Likewise, the weighing of evidence. You can't file a Q claim and be like, one examiner said this was related to the service and the other examiner said it wasn't. You can't go back and relitigate the issue of VA, favoring the unfavorable nexus. It's got to be undebatable. It's got to be black and white that there is no other option except to grant the benefit.
What would you say is the most common reason that Q claims are denied, or is there one?
A lot of vets file Q claims that are just not winnable. And there's nothing wrong with that. I always tell vets there's no harm in making a Q claim. The worst they can do is say no. And so if you feel strongly that you have a Q claim, go for it. Again, you just have to, all the evidence at the time has to support whatever you're trying to get granted. If there's any negative evidence that VA can hang their hat on, then it's a weighing of the evidence and it's not undebatable. And so really the stars have to align to get a Q claim won.
Is there any circumstance that you see Q claims won regularly? Is there anything that was often messed up or is still?
Yeah, I mean, I think our most common Q claim are these 10% ratings for painful motion. Whenever I see a rating decision grant service connection and give a 0% rating for a joint, I'm immediately suspect that VA forgot to apply the painful motion regulation and at least give the vet that 10% rating. Because if a vet didn't have pain in that whatever joint they're claiming, they probably never would have made that claim. And so that anytime we take a case on, we review the entire VA claims file to see if there's any Q claims that we can make and win the veteran additional compensation. And I'd say that's probably our most common one.
Is painful motion.
Yeah, it's painful motion. The exam says there's pain in that joint, and VA still gives a 0% rating.
With filing a Q claim, is there any risk or are you putting your claims in jeopardy at all as far as like reductions or severance, anything like that?
I can't say that there's 100% no risk. The general advice is anytime VA's in your file, anything could happen. I've seen some VA employees who feel like it's their duty to like go back and review everything. It's really, really rare. But, I can't guarantee things. If VA's in your file, there is a slim possibility that they start looking at other stuff.
And that's kind of the way we feel anytime VA is in your file for any reason whatsoever. Just kind of depends on the person. But they can and sometimes do look around and find things that they feel need to be adjusted.
Yeah, but it is very rare. And if you're fairly confident you have a winnable Q claim, that shouldn't deter you. Because especially if VA tries to redo something that's generally pretty prevailable, you'll be able to win any proposed rating reduction in most cases.
I think that's everything I want to ask you. Is there anything that you can think of, any practical advice or anything that stands out in your mind from conversations you've had that you feel like you should share?
It's hard to win Q claims. But on the other hand, like I said, there's generally no harm in filing it. And so if you do think you have a Q claim, go ahead and file it. The worst that can happen is that VA says no. Just keep in mind that the record is locked to what it was back at the time of the decision. You can't add any additional evidence. The failure of the duty to assist is never Q. The weighing of evidence is never Q. It's got to be, literally black and white. The evidence was there. The law said VA had to grant it, and they screwed up and didn't grant it. Mm-hmm. Those are the winnable Q claims.
And actually, one last piece of practical advice. What is the form or how do people file a Q claim?
Yeah, this is the bane of my existence because VA doesn't understand this, even though their own internal manual says there is no required form to file a Q claim. It just has to be in writing. It has to explain what the Q is, and it has to be signed by the veteran or the veteran's representative. So in our practice, we usually use a VA form 21-526, which is just an initial claim form. And we write in the disability box, Q claim, see attached cover letter, and then our cover letter goes into detail and explains what the Q claim. When VA sees a 21-526, that usually triggers them to establish the claim. If you just submit a written statement, those almost always get ignored. And even when you file the 526, I'd say about a quarter of the time, we get a letter from VA rejecting our Q claim, saying it was filed on the improper form, and then we have to email the regional office or we contact the VA employee who rejected it, and we refer them to their own internal manual that says there's no required form for Q claims and we properly did it and you need to accept it. We waste so much time just trying to get VA to establish the claim. It's literally in their manual telling them, it just needs to be in writing and filed.
So as a warning to veterans that might be thinking about this, there could be some initial friction.
Yeah, and just getting it established and getting VA to issue a decision. And the other, I guess another piece of advice is expect that on your initial Q claim, the local regional office is probably going to deny it. Don't get discouraged by that. I encourage you, if you file a Q claim, the initial decision denies it, you should go on to the board. Q claims are complex. The regional office doesn't understand them. Their knee-jerk reaction is just to deny it and get it out of the way. Make sure you send it to the board so you actually get proper consideration from a judge instead of a frontline employee.
All right. Thank you so much. That's what we have for you today. If you have specific Q-related questions, please leave them below. We've been doing a lot of subscriber Q&A videos, and we'd love to answer your Q questions in a future video.
Thanks again for joining. As always, make sure to like and subscribe. See you next time.
Bye-bye.